Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we drink scotch with our pinky held high, and we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. Now, we have a question from YouTube user Influence Inc., as in INK, so I assume that is a clever name for a tattoo shop. Very cool. And Influence Inc. asks us, who is responsible for preparing audio video evidence for court? Is that the responsibility of the legal team or the paralegal? So I can tell you that it depends firm to firm. I early in my career had jobs where I was up all night preparing audio video stuff in clips for court use the next day, because a witness in a trial lied a bunch, and we had video evidence from a variety of sources that proved that person lied. So we kind of did like a clip reel of remember when you told the truth that time? And, so that was fun. And, it was up to 4 a.m. and I was doing that myself. Now, that's going to be because generally in most firms, if there is a trial emergency, the attorneys are the ones who will stay late and do that. Generally, right? Like, listen, that's not true of every firm, but it's tough. If you tell most paraprofessionals, hey, I need you to work to 4 a.m., a lot of them are going to say, I'm sorry to hear that. That must be really hard for you, right? And that's the nice version of what they'll say to you, right? That being said, there's a lot of paraprofessionals who know a lot more about audio and video editing than the attorneys do. And so if you can, you have them do it during business hours and, everything's prepared. So it's going to depend who at a given firm has that skill set. Certainly if the paraprofessionals do it, the attorneys will review it before it goes in. Like, that's not it's not a situation where you're just going to just do it and go in blind, right? Like, whatever's prepared has to have eyes on from the trial team to know what they're dealing with, right? Like, they can't go in and get blindsided by their own evidence because something wasn't spliced right or was edited too much to be deceiving, right? Because, you also can't be deceiving, right? Like, if you edit a video in a way that makes it appear to be something it's not, you're going to have a bad day. You're going to have a real bad day if opposing counsel's even a little bit competent. So generally speaking, there's a variety of things the trial team's going to be looking for to determine what, if this evidence is what they need. Is it ethical? Can they use it in the current format? Were their instructions listened to when it was being prepared? Does this evidence comply with the court's procedures? The court's, specific rules as promulgated on the federal court's website or whatever it is, or at a state court, however they do it, wherever you are. I can't speak to every state court. And that's worth noting. A lot of these federal court judges and magistrates are going to promulgate their own rules for how these things get submitted. And also, the paras are going to do reminders like, hey, you need to ask for, some courts still use overheads. The flat things with lights on them, and you put there's a fly in here. You put the blank sheet with whatever the picture is, and the light shines up, and then it has a mirror, and it puts it on the wall. You still see those in courts. I think those went away in third grade for me, but those still exist in some courts. And then other courts are going to have overhead projectors and have upload and certain formats and giant video screens. There's some courts that have 85-inch TVs now, which is cool, but you got to make sure you got the right cable. Make sure you bring the HDMI cable. Seen some folks have a real bad day thinking the USB was going to be all it took. So a lot of times you're going to have the paras take a first pass at figuring stuff like that out. Generally at our firm, most of that work is done by attorneys, although certainly there's always a lot of activity from paras. That team mentality has value, right? I don't know if I don't get the gist from your question that you're like, I don't want paras working on my case. I don't trust paralegals, right? That's a mistake. Don't feel that way, right? That's akin to being like, oh, I don't like nurses when I go to the hospital. Don't do that. That's dumb, right? Don't. Are doctors good and are they going to help you? Generally, yeah. Is it a good idea to say you don't want to deal with nurses? No. That's a really good recipe for death. Like that's a really bad decision. And so too here, if you're like, don't let paralegals look at my case. No, don't do that. But feel free to be like, hey, the attorneys looked at all this stuff, right? Like that's a legitimate conversation to have with your legal team, right? Like, hey, you put eyes on the evidence before it got submitted, right? That trial team better say, of course. Might not have been the head trial attorney, but some attorney from that team had better have done that, right? And I'm with you there, 100%. I'm just saying, don't try to get the paralegals off your team. Like, that's not an intelligent approach on your part. And I don't think that you're doing that. I'm saying in generality, like anyone out there, don't do that. Paralegals have a wealth of knowledge. Many of them, like when I was a baby attorney, a paralegal taught me how to practice law. And the other attorneys around me were busy, right? They could answer my questions, but they weren't going to be like, here's how we do discovery. Here's how we format it, right? Whereas a paralegal, who I'm still friends with to this day, was like, yeah, stupid. Come here. I'm going to show you how to do the thing, okay? You know? And he has years, decades of knowledge in this field, right? There's paralegals that I knew who did better discovery demands than the attorneys. Why? Experience, but also just time, the time to sit there and think, right? That's how you dig deep in discovery. You sit and think. The limit on how you prove something is the human imagination. Always. So if you're sitting there and you're working the imagination, you're doing the Winnie the Pooh, think, right? That time spent is where you get the lightning bolt that's like, oh, I gotta check the lunchroom receipts to know when this bad actor, he says he wasn't there that day, but the lunchroom goes to his account with the facility, and I could probably prove he was there that day because my client says he was there, right? Like, it's not immediately, you might not immediately think of that, but if you're doing the think, like that time is when those thoughts develop. You know what people don't tend to give the attorneys on a legal team? Time. They don't give them time. We try to do that differently, but I know a lot of firms that will wildly overschedule their attorneys, and the attorneys are barely making deadlines, barely returning phone calls to clients, barely getting their trial prep done, right? Because they're so overburdened, right? In that scenario, who's doing the think? It's the paras. It's the paras. Is that ideal? No. Everyone should be doing the think. The attorney should do it. The paras should do it. They should all compare notes. Multiple attorneys and multiple paras in an ideal world would all do it. And I mean, listen, our approach is different kinds of attorneys, different skill sets for different attorneys, form a team of 3 at a para team, right? That's the team. That has huge advantages. Different people think of different things. And that matters a lot when you're looking to reduce risk and add value. So, Influence Inc., I don't think you were in any way hinting that you don't want paras in the team, but I ranted anyways. Paras are irreplaceable. They are assets to your case and wonderful. And in our field, I don't think paras should do as much. Listen, in personal injury, paras will write motions. In the realm of employment law, that it's a more complex form of litigation. I don't think that's really appropriate most of the time. It's a rare para in this field who should write a motion, right? In personal injury, most of the time, writing a motion is filling in blanks. in a piece of paper. That's what personal injury calls writing a motion, as I misuse air quotes. In our field, motions are complex, bespoke pieces of argument drafted after hours and days of research, right? It's just not the same thing. So no, listen, I don't really think pairs in our field should generally be writing motions, but they should, without a doubt, have input in discovery and in editing, discovery production, preparing it for production, bait stamping, of course, but also just preparing exhibits for trial. Trial binders are often prepared by paraprofessionals and reviewed by the attorneys. These are things that should happen and do happen, and routinely that is how things are carried out, right? And clients are immediately going to be like, well, but you're having a lower paid person do it. That's not necessarily the way to think about it. Like, that person is lower paid not because they're not as valuable. That person is lower paid because of fate and the way the world broke and like all the stuff that happened in their life, and they just didn't happen to go to law school. That's why that person's lower paid. It's not because they're less capable, right? And frankly, I hope those people do go to law school. Often those people will become much better attorneys than many of my peers. Frankly, I can think of a couple who'd be better than me, right? So, and influencing, you're not doing this. I know I'm not putting any of this on you. I'm just vibing on your question. Anyways, I hope this was a helpful answer. If it was, like, subscribe, comment down below. It helps me to help more people, just like you.